Tantor Audio, a division of recorded books, presents The Original Meaning of the 14th Amendment, Its Letter and Spirit, by Randy E. Barnett and Evan D. Bernick. Forward by James Oakes. Narrated by David Vries. Forward. There are few historical cliches more hoary than this one. The abolitionists were a tiny, beleaguered minority, widely despised all across the North. The evidence compiled by Randy E. Barnett and Evan D. Bernick strongly suggests that this is a cliché badly in need of revision. Not because the abolitionists were in fact popular, they were not, but because they were influential, profoundly influential in fact, for it was the constitutional abolitionists who developed, as the title of this book says, the original meaning of the 14th Amendment. Historians do not write books like this one, aimed as it is at getting the justices of the United States Supreme Court to change the way they interpret the Constitution. Written by two law professors, this book is explicitly, unabashedly designed to persuade the court to reconsider some long-standing constitutional assumptions about the 14th Amendment. But to make their case, the lawyers have written a history book. The questions they raise are deeply historical. Where did the phrase privileges and immunities originate? What did the phrase originally mean, and how did that meaning change over time? What did it mean by the time the authors of the 14th Amendment invoked it? So too with due process of law and equal protection of the law. Where did those terms originate? And what did they mean in 1868 when Republican lawmakers inserted them into the amendment? To be sure, Barnett and Bernick are originalists. They would have the Constitution interpreted, even today, in accordance with the original public meaning of the text. At first glance, this might raise eyebrows among my fellow historians. We are generally more comfortable with multiple or conflicting meanings, with meanings that change over time. We tend to be empiricists more than theorists. We are willing to consider original intent as well as original public meaning, and we don't usually distinguish between the two. Although we prefer contemporary evidence, we are often forced to rely on memory, fallible though memory undoubtedly is. And yet, original public meaning, though terminologically alien, is conceptually familiar to historians. Think of it as reading ideas in context, not unlike what Quentin Skinner challenged historians to do several decades ago. Nor should historians be too concerned that originalism necessarily freezes the Constitution in time. The 14th Amendment, as Barnett and Bernick read it, authorizes the federal government to protect the civil rights of citizens in the states. This, they tell us, is its original and therefore unalterable meaning. What has changed over time, however, is what the political culture has deemed to count as a constitutionally protected civil right. In the early republic, for example, voting was considered a mere political right, a right that varied from state to state, a right that could be granted or withdrawn at the pleasure of a state legislature. Voting was still thought of that way when congressional Republicans drafted the 14th Amendment. But by 1920, Barnett and Bernick argue, the right of citizens who had reached the age of majority to vote was deemed fundamental. What was once a mere political right to suffrage had become a fundamental civil right. Once that happened, the authors argue, the 14th Amendment empowered the federal government to protect every citizen's right to vote. Because a right that comes to be accepted as fundamental cannot almost by definition be taken away, the 14th Amendment created a floor, but not a ceiling for the privileges and immunities to which we are entitled. In this telling, then, the unchanging original meaning of the Constitution allowed for a Constitution that can adjust to changes in the political culture. The number of constitutionally protected civil rights could rise, but it could not fall, except by a formal constitutional amendment that changes the meaning of the text. This is where the abolitionists come in. for they were instrumental in changing the way Americans came to think about the privileges and immunities of citizenship. According to Barnett and Bernick, the original public meaning of the Constitution of 1787, was that civil rights were protected as a matter of interstate comity. But states themselves could respect or disrespect rights as they chose, as long as every state citizen's rights were respected or disrespected in the same way, and not all states considered African Americans to be citizens of the United States. As the debate over slavery intensified, abolitionists began to argue that some rights were fundamental, that free blacks born in the United States were citizens, and that every U.S. citizen was entitled to the same rights everywhere. In the abolitionist reading, for example, no state could deprive any citizen of the rights of due process. The radicals who pioneered this way of thinking, Lysander Spooner, William Goodell, Gerrit Smith, and others, were dubbed constitutional abolitionists by the historian Richard Sewell, and more recently Manisha Sinha has labeled their doctrine abolitionist constitutionalism. By the 1850s, the radical precepts of abolitionist constitutionalism had infiltrated American politics and became the baseline premises of the new anti-slavery Republican Party. Defenders of slavery responded in kind. They, too, began to argue for a fundamentalist understanding of rights, in this case a slaveholder's right to hold property in human beings. So fundamental was this right, Chief Justice Roger B. Taney would argue, that the Constitution obligated the federal government to protect slave property in the territories. By the 1860s, then, there was wide agreement that the privileges and immunities of citizenship were fundamental, and that the federal government was therefore obliged to protect citizens in the enjoyment of those rights. The significant point the authors make is that the original meaning of the 14th Amendment is to be found in the anti-slavery constitutionalism that was developed by abolitionists in the decades between the Revolution and the Civil War, particularly after the Missouri Crisis in 1820. By the time congressional Republicans proposed a 14th Amendment in the immediate aftermath of the Civil War, they understood their proposal to mean several things. Blacks born in the United States were citizens. All citizens were entitled to a number of rights, some of them enumerated in the Constitution, some spelled out in the first 8 amendments, and some unenumerated. These rights were fundamental, not simply a matter of mere state comity. Consequently, the federal government was constitutionally obliged to protect those rights in the states. This is a bracingly expansive reading of the original meaning of the 14th Amendment. No doubt, constitutional scholars will debate its merits or demerits as an originalist thesis. No doubt historians will similarly debate it as an interpretation of Reconstruction. But to this reader, Barnett and Bernick have made at least one point in this superb book that seems beyond doubt. The abolitionist movement bequeathed to all Americans, through the 14th Amendment, a better Constitution, an egalitarian understanding of citizenship, and a more robust conception of our fundamental rights. James Oakes. Preface. The Letter. On March 12, 1871, Supreme Court Justice Joseph Bradley penned a remarkable letter to a federal district judge in New Orleans who would one day join Bradley on the nation's highest court. Judge William Woods was mired in a case involving the constitutionality of the Enforcement Act of 1870, an ambitious piece of civil rights legislation crafted by a Republican-dominated Congress to enforce the recently adopted 14th Amendment. Judge Woods sought Bradley's advice because the justice also served as the judge for the Federal Circuit in which Judge Woods's district was located. At issue in United States v. Hall was whether Section 5 of the 14th Amendment empowered Congress to criminalize private conspiracies against the First Amendment rights of free speech and peaceable assembly. The case arose from the indictment of 2 white men for violently breaking up a political meeting of mostly black Republicans, killing 2 and wounding more than 50 people. The defendants argued that because no federal rights were at issue, the charges should be dismissed. In Barron v. Baltimore, decided in 1833, the court held that the first 8 amendments constrained only the federal government. They did not restrict the exercise of state power, and they did not authorize the federal government to reach private individuals. Had the 14th Amendment changed this? Woods wanted to know what Bradley thought. In his 4-page handwritten letter, Bradley succinctly described what he took to be the meaning of the text of the 14th Amendment. To our knowledge, a transcript of Bradley's draft of this letter, which resides in the New Jersey Historical Society, has never been published in its entirety. So we produce it here, noting its original underlining and crossed-out passages. Washington, March 12, 1871. My dear Judge, I am sorry I could not have answered your letter of 7th last sooner, but my duties here have been so arduous that it has been impracticable. I will now attend to do so. The 6th section of the Act, known as the Enforcement Act, makes it felony for 2 or more persons to conspire together or to go in disguise with intent, 2 or more persons to conspire together or to go in disguise with intent, underlined, to prevent a citizen of the U.S. from registering or voting, or to injure or intimidate him to prevent the free exercise and enjoyment of any right or privilege secured to him by the Constitution or laws of the U.S. You ask whether the breaking up of a peaceable political meeting by riot and murder when committed simply for that purpose, without any defendant's intent to prevent the exercise of the right of suffrage, is a felony under this section in view of the First Amendment of the Constitution, which says that Congress shall make no law abridging the right of the people peaceably to assemble and to petition the government for a redress of grievance. Supposing the First Amendment to embrace the right peaceably to assemble for the purpose of discussing political questions, which I think it does, the case is underlined within the words underlined of the statute. The right is a right secured underlined, by the Constitution. True, it is secured underlined, only as against the action of Congress itself. But still, it is a right that is secured. But where Congress is prohibited from interfering with underlined, a right by legislation, does that authorize Congress to protect underlined, that right by legislation? The same amendment prohibits Congress from passing any law respecting an establishment of religion, or prohibiting the free exercise thereof. Does this give to Congress the power to protect by law the people of a state in the free exercise of religion? Is not that subject left to the discretion of the states or the people? Until the passage of the 14th Amendment, this was undoubtedly so. Does the 14th Amendment, in giving Congress power to enforce its provisions by appropriate legislation, make any alteration in this respect? By that amendment, Section 1, no state, underlined, shall make or enforce any law, underlined, which shall abridge the privilege or immunities of citizens of the United States. Nor shall any state deprive, underline, of life, liberty, or property without due process of law, nor deny, underlined, to any person within its jurisdiction the equal protection of the laws. Now, the privileges and immunities of citizens of the United States here referred to are undoubtedly those which may be demonstrated fundamental underlined. See Corfield v. Coryell, 4 Washington Circuit Court Reporter 380. And among these, I suppose we are safe in including those which in the Constitution are expressly secured to the people, either as against the action of the federal government or the state government. If this is so, then undoubtedly Congress has a right by appropriate legislation to enforce and protect such fundamental rights against unfriendly or insufficient state legislation. I say unfriendly or insufficient, for the 14th Amendment not only prohibits the making or enforcing of laws, underlined, which shall abridge underlined, the privileges of the citizen, but prohibits the states from denying underlined, to all persons within its jurisdiction the equal protection of the laws. Denying underlined, includes inaction as well as action, and denying the equal protection of the laws includes the omission to protect as well as the omission to pass laws for protection. Our controversy with England at this moment is not only that her neutrality laws were not sufficient, but that she did not properly enforce those which she had. It is a poor consolation for me to be told, our laws are sufficient to protect you if those laws are not enforced, and any rights are supinely permitted to be invaded. Therefore, to guard against the invasion of the citizens' fundamental rights, and to secure their adequate protection, as well as against state legislation as state inaction or incompetence, the amendment gives Congress power to enforce the amendment by appropriate legislation. The extent to which Congress should exercise that right will depend upon its discretion in view of the circumstances of each case. The extent to which Congress should exercise that right will depend upon its discretion in view of the circumstances of each case. Phrase is crossed out. And as it would be unseemly for Congress to interfere directly with state enactments, or state officials, phrase is crossed out, and as it cannot compel the activity of state officials, the only appropriate legislation it can make is that which will operate directly on offenders and offenses and protect the rights which the amendment secures. The extent to which Congress shall exercise this power must depend on its discretion in view of the circumstances of each case. If the exercise of it in any case should seem to interfere with the domestic affairs of a state, it must be remembered that it is for the purpose of protecting federal rights, and these must be protected whether it interferes with domestic laws or domestic administration of laws. In my judgment, therefore, the case you suppose is within the law, and the law is within the legislative power of Congress. Yours truly, Joseph P. Bradley. P.S. I expect when our court adjourns, about the 1st of May, to visit Savannah and Mobile in succession, and spend, say, a fortnight is crossed out, week or 10 days in each place, perhaps longer. If you will make arrangements to have cases of special importance laid over till I can appear, I will cheerfully hear them. I would a little prefer not to be bothering with jury cases unless you decide it important. I shall probably visit Savannah first. I doubt whether I can get as far as New Orleans. Should you specially wish me to hear any cases there, I might perhaps go there for a short time. In this letter, Justice Bradley summarized, with just one omission, our thesis concerning the original meaning of the 14th Amendment. The Privileges or Immunities Clause protects those substantive rights which may be demonstrated fundamental from being violated by state governments. These fundamental rights include the unenumerated rights discussed by Justice Bushrod Washington in the 1823 case of Corfield v. Coryell, which Bradley cites. They also include enumerated rights, such as those set forth in the First Amendment, which Bradley affirms were expressly secured to the people. The Equal Protection of the Laws Clause is not limited to barring state action, but also imposes an affirmative duty on states to act. As Bradley put it, denying includes inaction as well as action. A denial of the equal protection of the laws extends beyond a state's officials failing to protect the privileges or immunities of its citizens. It extends as well to failures of states to enact laws for their protection, or in Bradley's words, the omission to protect as well as the omission to pass laws for protection. Section 5 of the 14th Amendment empowers Congress to remedy the failure of state governments to protect these rights by creating its own federal enforcement procedures, to guard against the invasion of the citizens' fundamental rights and to secure their adequate protection, as well as against state legislation as state inaction or incompetence. The amendment gives Congress power to enforce the amendment by appropriate legislation. Finally, laws enacted by Congress pursuant to its Section 5 powers will operate directly on offenders and offenses. Indeed, given that Congress cannot commandeer or compel the activity of state officials, this is the only appropriate legislation it can make. Justice Bradley packed a lot into a 4-page letter. There is just one major component of our approach that is missing from his account of the original meaning of Sections 1 and 5. Bradley does not consider whether the due process of law requires a judicial assessment of whether the substance of state laws arbitrarily restricts the privileges or immunities of citizens of the United States. That issue was not implicated in United States v. Hall. Each element of what Justice Bradley so clearly saw and expressed in 1871 would be purged from our constitutional law, denied by the Supreme Court, and repudiated by generations of scholars. Indeed, Justice Bradley's own jurisprudence tracked the rise and fall of the original meaning of the 14th Amendment. Bradley's decline began in April of 1873 when the court handed down 2 pivotal decisions. In his dissenting opinion in the slaughterhouse cases, Bradley reiterated the fundamental rights theory of the privileges and immunities of citizenship that he conveyed to Judge Woods, and he determined that the privileges or immunities of U.S. citizens included a right to pursue a lawful trade or occupation. But then, the very next day, in Bradwell v. Illinois, Bradley published an infamous concurrence endorsing the constitutionality of the complete exclusion of women from the practice of law. 3 years later, Bradley joined the majority in United States v. Cruikshank, reversing the convictions under the Force Bill of the perpetrators of the Colfax Massacre. This was the horrific slaughter of dozens of black Republicans and 3 white Republicans that Eric Foner rightly characterizes as the bloodiest single instance of racial carnage in the Reconstruction-era. Contrary to the interpretation expressed by Bradley in his letter, in Cruikshank, the court held that the Privileges or Immunities Clause did not protect the rights enumerated in the Constitution from violation by private actors. Finally, in the 1883 civil rights cases, Bradley himself authored an opinion for the court holding unconstitutional key provisions of the Civil Rights Act of 1875 that prohibited racial discrimination in public accommodations. Contrary to his letter, Bradley's majority opinion limited the operation of the 14th Amendment to state action as opposed to state inaction. It would be another 82 years before Congress would again enact major civil rights legislation. When it did so, due to the precedent of the civil rights cases, Congress invoked its Commerce Clause power rather than its enforcement power in Section 5. Whatever may have moved him to change his mind, the overwhelming weight of the evidence shows that Justice Bradley's first instincts were correct. In this book, we urge the Supreme Court to change course and restore the original meaning of the 14th Amendment in full, the meaning described by Justice Bradley in his letter to Judge Woods. Doing so will surely require a change in some existing doctrine, but, as important, it will legitimate many current doctrines that have been called into question. Just as one swallow does not a summer make, neither does one letter establish the original meaning of the 14th Amendment. That requires the evidence we will present. But Justice Bradley's letter offers a succinct preview of all but one of our findings, and it shows that our thesis is no mere academic theory. It was once considered a nearly self-evident truth. Introduction. The Letter and Spirit of the 14th Amendment. Nothing in the Constitution of the United States is more important to contemporary American law and politics than the 14th Amendment. This book provides a comprehensive account of the original meaning and purposes of those components of the amendment that are most salient and controversial today. Those components are Sections 1 and 5. Here they are in full, unbundled to highlight their principal parts. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 5. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Sections 2, 3, and 4 of the 14th Amendment are of great historical significance, and Section 2 in particular still carries practical weight. But the citizenship, privileges or immunities, due process of law, and equal protection of the law's clauses in Section 1 and Congress's enforcement power in Section 5 are far more frequently litigated and politically contested. And yet only relatively recently have scholars provided accounts of the original public meaning of Sections 1 and 5, the meaning conveyed by the text to the public when the 14th Amendment was ratified into law in 1868. That shouldn't be as surprising as it probably is for many listeners. The focus today on original public meaning is a product of a legal movement that is relatively young. Prior to the rise of originalism in the 1980s, proto-originalists focused their attention on the original intentions of the framers of the Constitution. This approach characterized Raoul Berger's 1977 tome, Government by Judiciary, The Transformation of the 14th Amendment. In a very real sense, modern originalism arose in response to Berger's book. Our book is the culmination of that response. It provides a theory of the 14th Amendment's original public meaning that honors the text and history, including a history of constitutionalism outside the courts that is often overlooked. And it articulates a novel strategy for implementing today what Schuyler Colfax, Speaker of the House when the 14th Amendment was framed and ratified, called the gem of the Constitution in a way that is faithful to the goals of those who fought to make it law. The intellectual origins of modern originalism. In 1980, Stanford law professor and future dean Paul Brest wrote a path-breaking article in which he coined the term originalism. Brest's principal targets were Raoul Berger and Robert Bork. It was Brest who first dubbed Berger and Bork originalists and their approach originalism. By originalism, wrote Brest, I mean the familiar approach to constitutional adjudication that accords binding authority to the text of the Constitution or the intentions of its adopters. He contrasted originalism with what I shall call non-originalism. Brest's article may well have provided the most influential labeling scheme in the history of constitutional theory. Because Berger, Bork, and others who appealed to the intentions of the framers lacked an explicit formulation of their methodology, Brest constructed one. He conceded up front that, at least since Marbury, in which Chief Justice John Marshall emphasized the significance of our Constitution's being a written document, originalism in one form or another has been a key theme in the American constitutional tradition. Nevertheless, Brest took aim at what he called strict originalism, which he said was characterized by its strict intentionalism. For the strict intentionalist, the whole aim of construction, as applied to a provision of the Constitution, is to ascertain and give effect to the intent of its framers and the people who adopted it. Brest then identified the problem with strict intentionalism. Strict intentionalism requires the interpreter to determine how the adopters would have applied a provision to a given situation and to apply it accordingly. The enterprise rests on the questionable assumption that the adopters of constitutional provisions intended them to be applied in this manner. But even if this were true, the interpreter confronts historiographic difficulties of such magnitude as to make the aim practicably unattainable. As we will note, Breast's focus on the application of a provision to a given situation anticipated an
Sample complete. Ready to continue?